and Senator Jillian van Turnhout.
Thank you very much. 2002 referendum was actually my first referendum vote, and for 21 years I've worked in the private sector for 15 years, and then I headed up different children and youth NGOs both in a voluntary and professional capacity. And in these roles I've always listened to the debate, but I've never actually had to actively formulate a position. So I do feel a little bit nervous now, because this is the first time I feel I'm publicly stating how I feel on this issue. The hearings we had in January and both over the last 3 days have given me an opportunity to form a definitive position. And I'd like to begin by thanking all of the experts, both in January and over the past 3 days, for their informative and sometimes contradictory testimonies, but all has been extremely useful. I'd like to thank my colleagues, the Secretariat, and in particular our Chair, Jerry Buttimer. To start, I can now say in confidence that I do support the Government's decision to legislate. This bill only deals with difficult, rare and complex circumstances. Of course, I have some caveats. I am concerned about us separating out physical and mental health. I feel in the wider public debate it will be a step back for us. I do believe that therefore heads 2 and 4 should be merged. I don't see, and I have not heard legal reasoning. I've obviously heard contradictory reasoning, but from what I have taken, I do not believe that they should be distinguished. As noted by the expert group, a differentiated treatment does not appear to be required for medical or practical reasons. Dr McCarthy said to us, suicide in pregnancy is a real risk. It does happen. There is no distinction in Article 43.33, and so to exclude it in this bill, I think, would be to change the law. I don't believe that we should have any differentiated treatments. I am concerned about the scope of Head 19. I think it's extremely broad, in fact too broad. It covers a wide range of activities, including and beyond that previously covered by Section 58 and 59 of the Offences Against the Person Act 1861. Some of the scope is unclear about what exactly is covered, and the penalties, I believe, are disproportionate. I have concerns over the appeals process timelines, a conscientious objection. I think we need a further discussion on exploring this issue. I am concerned in relation to the silence in relation to children, specifically young girls. I believe we do need specific legislation to address many of the issues raised over the past few days. I am troubled that we will compound voiceless children who are in the care of the state in this legislation. Our hearings have also highlighted, Minister, the importance of the Assistant Decision-Making Capacity Bill, which is urgently needed. Chair, I must say I found any association, actual or implied, between abortion in Europe and the Holocaust to be distasteful in the extreme. Besmirching the memory of millions of murdered Jews by turning them into a pawn in the abortion debate displays a woeful ignorance of the Holocaust and a woeful disrespect of the memories of the victims. Whatever one's opinion on the abortion issue, the debate between well-intentioned people on both sides of the argument, there are no two sides of the Holocaust. I would respectfully encourage my colleagues to desist from making this highly offensive connection during the continuing debate. We must not allow the 6 million victims of a diabolical, premeditated attempt to eradicate an entire people to be dragged into this abortion debate. In ending, I was appointed by the Taoiseach Enda Kenny, particularly in recognition of my work as children's rights. Advocacy on children's rights has not been an easy road to travel, and therefore on this decision and talking about child protection, I did have to consider my position, but I stand here in confidence, and I will continue to constructively engage with care, conviction and compassion.
Good, Margaret.